Hello again, everybody. Hello, I'm back. Hello. That didn't take very long. Oh my goodness, to come back. So here we are again. Hello. Let me get everything set up here, everyone. We do have a new filing out of Georgia. Hello, welcome. Oh, welcome in, welcome in. Hello, hello. So we do have a new filing, and it's huge. So I'm not going to be reading the entire filing, but I figure we could kind of go over it. Hello, Deborah. Hello. Good morning. Good morning again for everyone who was here earlier today. So I did pull this filing. It was just filed this morning at 9:55, so I thought we would go ahead and go through. Now there's just no way for me to possibly read this entire this entire motion, so I thought we could go through it together and just kind of look at the different parts of it. I know. Good morning, good morning. I know I'm not ready either. It's a lot, but this was just filed, everyone. So I was on earlier today with an update out of the Florida case, and now here we are with a brief update out of the Georgia case. So have you gone over Trump's appeal to SCOTUS? Yes, but I've not done a full live on it, but I will be doing a full live on that at some point very soon. So I do have the briefing dates though, which I can go ahead and put on the calendar. So we have on January 18th, everybody, is when the SCOTUS amica briefs are due. So let me add this on here. Amici briefs are due. So we can add that to our calendar. We also have a brief on the merits due on the 31st. So this is where the party has to have theirs. So brief on the merits is due here. And then we have the reply due on February 5th. So we've got reply due. So I'll just put reply up here. We got a lot going on that day. Replies due here, and then that's it. And then we are set then for oral arguments for SCOTUS then on the 8th, everybody. So that is when our oral arguments are scheduled for the Colorado case, just to remind everyone kind of where we are. So those dates are added here. Lawyers are filing frivolous appeals. Well, there's a lot. There's a lot going on. There's a lot going on. So for sure. So I wanted to, rather than read this, I think this is almost 70 pages long. So rather than doing that, I will go through and annotate and kind of break this one apart. Any luck with Pearl? Well, she's doing okay at the moment. We're gonna see how things go. I don't know. We'll figure it out at some point. Oh my goodness. So this was filed just this morning, everyone, just a couple hours ago, and this is out of Georgia. Again, I did do a quick update on the Florida case earlier this morning, and I'm back again. I'm gonna kind of be on and off throughout this week when we're getting these updates. It's going to be a very busy week, but I will be at my scheduled time, 7 p.m. Central on Tuesdays and Thursdays this week. So everything else is just kind of a bit of a bonus. So yes, it's a copy of the other ones. Exactly, right. So I'm not going to be reading this verbatim but I thought we could go through it. I will just annotate it and acknowledge that we again have another situation where we have, hello, good to see you, where we've got another motion filed regarding this idea of immunity. So as I go through this, I'll just kind of, explain the different pieces. So Again, we've got Trump, and he's filing this in the Georgia case, and he's moving the court to dismiss the indictment in this case, and the support relies on his memorandum of law. So he's going into, I'm surprised they didn't give Pearl. Yeah, I know, that would have been nice, Suze. I would have, where do I get that? But my vet actually called me this morning to give some helpful advice. So we will see. She did have some of her medicine this morning. We'll see how it goes. Oh my gosh. We'll see how it goes. So here we go, everyone. We're back into this realm of pleading that there's this absolute immunity, right? So this question continues to be in all of the cases. That's why it's so important for it to be resolved. So this issue, again, is being argued in front of the D.C. Circuit tomorrow. But here, this was filed just this morning. So Mr. Trump, presidential immunity from criminal prosecution for official acts has deep roots in the separation of powers and principles of federalism, just as Fitzgerald held for civil immunity. And that is incorrect. Sticky note, yes, I'm not going to be reading, Deborah. I'm not going to be reading. I'm going to just be flipping through and annotating. So I won't be able to use the sticky note at this time. This will literally be the only sentence I'm reading. But yes, so would that apply to state law? Yeah, that's a great question though, isn't it? Are you immune from state law? No, you're not. But then again, this immunity, you're not free from any of it. Now, one of the things that I've heard a lot of the commentators talking about, and I'm just going to chat with you, everyone, as I go through and put in some annotations here. But one of the things that a lot of people have been talking about is this idea that the Supreme Court, after the Court of Appeals in DC decides on this issue, tomorrow they hear those arguments, but that they just will not grant cert. They will just refuse to hear it. And I'm leaning that way myself. I'm leaning in that direction. If you think about it, the DC circuit is really the top circuit in the US. And, we have our sets of circuits, and the DC is really our top court. So for them, they are the top court other than the US Supreme Court. So in my opinion, I think the US Supreme Court will go ahead and bump it back down and just say, no, we agree with the lower court in this situation. Okay, no problems. Yes. Yeah, Deborah, I tell you, if I read through this whole thing again, yikes, I think we would all lose our minds just a little bit. I've never heard that. Yes. So, all of our federal courts, right? We've got 3 levels: the trial court, the appellate court, and then the Supreme Court. So if you think about all of the different circuits that we have all over the U.S., the D.C. circuit is the one where the Supreme Court sits. So that's kind of the top court. Into the corn in the back of the throat. Oh my gosh, I'm going to have to try that. I tell you, this kitty cat, she is just, I love her spice, but it's a lot. Oh my gosh. So, but as we go through this, that's why I keep thinking, he's filing this immunity question now in the Georgia case, and it is a state case. Did he file it in New York? He tried under the Jean Carroll case, but the Court of Appeals said, look, you didn't file this timely, so you're not going to be able to use your immunity in this civil case. And then, I've not seen where it was filed in the criminal case in New York yet at this point. Is the DC appeals higher than, say, the Fifth Court? So that's a really good question. And I would say, now in a hierarchy, let me see if I can get a visual here. I should have a map. Let me grab a map if I've got my district map with me. I may not. Let me just see. No, I don't have my circuit court map with me. But a good way to kind of visualize how it works is we have all of our circuits. So we'll just make this the United States, okay? Here's Florida. Okay. Oh my goodness, and Alaska and Hawaii. So the Kansas, Texas. This isn't turning out well, everyone. But anyway, so we're broken up into all of our different circuit courts. So all of our circuit courts, they're all equal. So everyone's equal. No one's better than anyone else. But what's interesting about the DC court, though, is that although it's not necessarily more important, it's just known as the top court in the country, one step below the Supreme Court. And that's because of the judges that sit there and the cases that come out of the DC circuit. So, it's the top appellate court at the seat of our government. So it has this reputation for being just the top court. I mean, again, all of our circuits are equal, but when you talk about the DC circuit, it's just seen as a one step above, not necessarily jurisdictionally a step above, but just as far as reputation goes, it's kind of a step above. I like the picture. Oh dear, I had to move the picture. I'm not sure if that was a cow or what was going on there. Pay $200 for that drawing. No! Oh my goodness. Yes, they didn't teach the drawing part in the law school, people. I'm sorry about that. Oh my gosh, whenever I would draw something up on the board for my students in class, they were always like, should we take a picture of that? Or is that really necessary? Is that going to be on the exam? Oh my goodness. Yes. So the fact that it's out of the DC circuit as opposed to something like the Second Circuit, right? Or the Fifth Circuit. Each circuit, again, is their own independent entity and they have their own jurisdiction. But again, because of the location of the DC circuit and the fact that Chief Justice Roberts, is the final word anyway in that circuit, that's his job as the Chief Justice there. It's kind of seen like the Supreme Court of the federal courts before the U.S. Supreme Court. So it's kind of seen as that way. So I can't even draw a hood stick person. Oh, that's so funny. Are rulings held above other circuits? So that's a great question. And I would say, I'm not sure that it's necessarily held above, but if you have circuits closer to where you're at, let's just say, for example, it'd be better if I had my circuit map, but I don't. If you just look jurisdictionally and you're in Texas and you're talking about your circuit in Texas, but your circuit in Louisiana, your circuit in Oklahoma, those are probably going to be better cases than, say, something out of New York, right? Because you're closer as far as location goes. So you're going to want to look closer to where you are, to states that are similar to you. Especially when you get down the middle, the central part of the United States. You really want to see other states similar. So rather than use a California case, if you're in Texas, you would want to bump, to a Louisiana case or to a Missouri case. That might be more persuasive. So they're not necessarily better than one or another. It just can be more persuasive if you're talking about neighboring states. Like the federal government is going after the federal government. Right. Yeah, I mean, that's kind of how it is. And because, again, we have this federalism split, again, I'm turning my picture over, but we're split, right? We have our state courts and then our federal courts and all of our circuit courts. Again, we have our trial courts here. All of our circuit courts, again, are our Court of Appeals. The Court of Appeals here, and they're all equal, but that DC court is literally down the street from SCOTUS. So because of their location, they have just a bit of a higher level. Laws in Louisiana different than other states. True, to some degree, although surprisingly, it's not quite as different as a lot of people think. And that's because in Louisiana, yes, they do use the Napoleonic Code, which means their res judicata is a little bit different. But it's not so much different that it is, way outside of the realm. There are definitely attorneys in Louisiana with specialized knowledge, but in Louisiana, their federal circuits run the same as everyone else. So the Napoleonic Code is just to state law and only in certain situations as well. But it is a little bit different For sure. It's special. Louisiana is special, everyone. We need to acknowledge that. Very special in many ways, not just that. Oh my goodness. All right, so here's our first argument, everyone. Again, I'm just annotating. I'm not going to be reading through this 70-page motion, but I'm just annotating. This was a motion filed in Georgia by Mr. Trump. So he's saying President Trump's prosecution is barred by presidential immunity. And we've heard this before. This is part one. President Trump has absolute immunity from criminal prosecution for actions performed within the outer perimeter of his official responsibility. And that, again, is so opposed to the fundamental principles of our legal system that even bringing it up seems almost frivolous in the legal world. Almost frivolous. It's technically not, but it's frustrating for those of us that have worked here, because to see someone making an argument like that, it's the equivalent, and actually there have been many interesting arguments put out. It's the equivalent of saying, oh, we don't have the 24th Amendment. It just doesn't work. Like, what are you talking about? That's not how the law works. Everything he says is nonsensical. It feels that way. Business law professor got a kick out of telling us we're unique with the laws. That's true. That's true. There is some uniqueness there in Louisiana for sure. And rightfully so. It's a very, unique cultural area. Lots of things that are special to Louisiana for sure. When does it get to the point of being frivolous? I think we've already gotten there, Kitty. I feel like we're already there. I feel like we're in the frivolous world at this point. But as far as any kind of sanctions or accountability goes, it will probably have to be after the cases are done. It's typically how it goes. Rather than interrupting an ongoing case, many times the courts will wait for it to end. And that's how it was in the sanctions that were issued in the Trump versus Clinton case, where they were suing for defamation, and those sanctions came in later at the close of the case. And also in New York, we were kind of winding down those cases at the point at which they were given sanctions. So the timing of the case is important, because I know they don't want to interrupt what's going on, because they don't want to have any kind of due process questions, but it takes a while for sure. If presidential immunity was for crimes, Nixon wouldn't need it to be. Yeah, exactly. That's exactly right. The judges must have patience of a saint. I don't think, well, first of all, yes. But second of all, I think they all realize that this is like a burning dumpster, right? And you're acknowledging, look, I've got a dumpster on fire in front of me, and unfortunately I have to take care of it. But if I get too close, it's going to burn me. So I think everyone is just trying to be careful on how to properly handle a dumpster on fire, is how I view it. So a lot of people, and me included, are like, oh, Mr. Trump's getting a lot of special treatment. And that's true, because we typically aren't having to deal with a dumpster fire. We're typically dealing with other things. That could be one element, but it's typically not an entire case, unlike what's going on in the Trump cases. So because of that, everyone is approaching with caution and being extra careful so that they don't catch on fire as well. Yes, dumpster fire. Well, I can't think of any other description for it, everyone. We're at a point where someone is literally filing a motion in Georgia saying that the president is immune from any kind of criminal prosecution. If that's where we're at in our court system, this is a dumpster fire. Oh my goodness. It's frivolous, but yes, I agree. It's still, love that your ring on your, oh, thank you. This is just an Amazon ring, everybody. This isn't even one from my travels. This is one of my winter rings. Is it because it's political? No, I don't think it's because it's political. I think it's just because of the questions that are being asked. And I'm not sure that and that's a lot of people are saying, oh, it's the politics, or it's the left, it's the right, but it's not. It's just a person of power in this country. And, what party they're associated with, that's a separate issue. But you have a former president. That's not political. That's just facts. So that level of power, you just have to deal with caution. Approach with caution. Any other defendant would have been behind bars. Oh, absolutely. The other thing too, what I've heard a lot from our military vets has been how frustrating the Florida case is because of how strict the military is regarding classified documents. And I've heard over and over and over again, look, if this had been me in the military, like I would have been in jail. I would have been in prison for 10 years, no questions asked. It would have just been done. We would have been over. As opposed to like kind of this, what several people have claimed is this nonsense going back and forth with presidential records. Because the way that it's taught in the military, if you're messing around with stuff like this, you're out. And so it's been very frustrating for a lot of military people that I have been speaking with when they're expressing like, how can this even be a thing? So, and I agree. I absolutely agree. 19-year-old National Guardsman. Right. Oh my gosh, Charles, exactly. Has anyone... No, I don't think so. I don't, at this point, they're so careful about it. They're so careful. I feel the documents are the biggest breach. I would agree, Sunlight. I think the Florida case doesn't get enough attention per se because it's not quite as, glamorous as some of the other cases, I guess. It's not as much of a shock and awe situation. But if you look at it from a security point of view, those are classified documents where, again, if you were in the military and you did something like that, you would be gone for a long time. So it's a huge, huge situation. And again, even in the filings in Florida, they're saying, well, we want to, make some of these available to the public. And, other people are like, are you out of your mind? So it's very frustrating and it's hard to watch. January 6th was, I don't downplay the documents. They're both huge offenses. It's a good point, Michelle. I think it's really kind of apples and oranges. I think, if you're looking at domestic threats, honestly, you're looking at January 6th. If you're looking at foreign threats, you're looking to Florida. So either way, we have huge threats going on, but it just depends on, at home or abroad. Both are threats, for sure. Only immune to prosecution for doing acts of his job, not illegal acts related to his next door. Exactly, Jennifer, exactly. And there's no absolute immunity for anyone when it comes to breaking the law. We just don't do that here. That's not what this country's about. We have a lot of problems, don't get me wrong. We make a lot of mistakes. We screw up a lot of things, but that's not something that we screw up. That's been here since the beginning, all the way back to Aaron Burr being held accountable for a duel he was in, That's like the very start of the country. They're not playing around with that. And he was vice president at the time when he committed that offense. So if a vice president of the United States in the beginning can't get away with something along those lines, we certainly aren't going to allow it the rest of the way. What about the missing binder? Trump requested it. Yes, that's a good point. The missing binder is still out there with huge questions involved. That's absolutely it. Absolutely it. It's a huge issue for sure. We've just got a lot of security issues, and I'm not saying anyone's particularly surprised about it, but it doesn't make it any. It's difficult. What type of immunity did Meadows get with the special counsel? Great question. I have no knowledge of any deal that he has made with special counsel, and I'm looking, everybody. I've looked through articles. I've looked through everything that's published, that's been made public. I have not found a single thing that has had a legitimate evidentiary link between special counsel and some kind of a promise to Meadows. I've just not found that yet, and I have looked. So I do not know. I know a lot of it's been reported, and I'm not saying that it's not true. I'm just saying I don't have any proof to show you what it is at this moment. I just don't have it. I will continue to look, though, and that is definitely one of the big pieces going around. I've heard it called limited immunity with Meadows. Right. Well, immunity has there's all different forms of immunity. You can have immunities for just showing up on a particular day, immunity from arrest. You can have immunity for certain topics. You can have immunity from prosecution, just for certain types of crimes, but not other crimes. So the immunity is just really a very individualized thing. It's case by case, depending on what the prosecutor needs, depending on what's negotiated out. So it will vary on the circumstances. Just read Cassie Hutchinson books. Mark Meadows was all over the binder. Yes, I heard that too. Thank you for providing an answer. Oh, absolutely. He claims absolute immunity for the president, but that's not a real thing. Well, right. It's not. It's not. And that's another thing that we're kind of getting into is this issue of, why do we keep having these kinds of pleadings and things that are clearly not legitimate pleadings, but are still going on. So and that's where the question of ethical issues comes into place as well, which I am continuing to work on. We do have ethical rules. If there's no basis in law or basis in fact, we're not allowed to file it. And those rules don't seem to be applying very strictly at the moment. At the moment, being impeached twice didn't slow him down. True. So when's Trump going to jail? Well, that's a great question. Presidential immunity was intended to prevent the president from being suable in office. Absolutely. And also, too, if there was some kind of question about, an unlawful prosecution, sure, I think it's legitimate. But, you don't have immunity from committing crimes. There's nothing that's going to protect you from criminal actions here. We just don't do that. Well, I suppose I say that, and then I say, well, we've got some diplomatic immunity, but and qualified immunity. So I guess there are some caveats to everything, but not at the president's level. We don't have it there. Oh my goodness. And for blatantly criminal actions, that's just never been part of what we've done here. Is the pay good being an attorney? No, it's not. It's not good. In every profession, you always have your top, 10%, 10%. That make all the money, and everybody else, it's just working hard. It's just like any other profession. Although we pay a lot more to become attorneys, we spend a lot of money in law school. We spend a lot of money to keep our license every year. We pay for classes and those kinds of things. But as far as huge cases come in, if you've got a products liability case, sure, you might bring in some serious money, but unless you get a huge case like that, it's just like any other job. You're just going in, fighting the good fight, and then going home and hopefully being able to get paid by clients, hopefully, if everyone's doing okay. But a lot of firms, have diverse kind of sets of laws that they do because things like workers' compensation, disability, those kinds of payments they're very, very low, which is absolutely fine. But you can't support an entire law firm, all of your support staff, your administrative staff, off of a couple of hundred Social Security disability cases. You're just not going to be able to fund your practice that way. So you have to really diversify. And sometimes you'll get a big client in and that'll carry you through for a couple of years, but sometimes you don't and things get tough. So no, it's not. Is it more than most? Probably, but again, it's also because we have to invest a lot up front. I'm not sure if that was a good answer or not, but my cousin does that. Yeah, environmental can pay pretty well. True, but you've got to put the time in. You got to put the time in on the front end. So you can do an environmental law case, and finally get it to court within that 5th or 6th year, but not have any way of paying for any of the work that you've done in those 5 years leading it up to trial. That's your own money that you're putting into that case and your time and your effort. Maybe you've got enough for some basic supplies, and again, I'm not talking about corporate work. I'm not talking about corporate counsel or patent attorneys, but those attorneys that are kind of in the field, in the trenches, we're not making a lot of money. It's just, and that's that's just part of the job. What docs are you highlighting? So right now, this is the motion that was filed by Mr. Trump requesting full immunity and requesting that the case in Georgia be dismissed based off of immunity. $200K just to get the JD from a public law school. The pay is very seldom equivalent. You got it, Tori. You're exactly right. Are you a partner? So I was a solo practitioner. I kind of had to put that to the side, but I was a solo practitioner. I did work in firms for a while, and I also did prosecution for the government as well. So I've worked for the government, I've worked private, I've kind of been all the way around. Is that a motion to dismiss the case? Yes, it is. Thank you for taking the time to share your knowledge. Oh, absolutely, absolutely. No problem. My pleasure, my pleasure. So, so this is the motion to dismiss, and it's very similar to all of his other motions to dismiss for immunity. In fact, it's almost identical to the one that's in front of the DC Court of Appeals that's supposed to be heard tomorrow. So there's not much that's been added to this from what I can see at this point. But so he's just filed it today in Georgia. Now remember, in Georgia we had a total of 19 defendants. 4 have pled out at this point, so we've got 15 defendants left. We don't have a trial date set. We did have DA Willis requesting a trial to be set in August based off of the trial schedule for the DC case and the Florida case, along with New York, although I'm not sure New York really came into it. But so she requested it for August. That has not been settled at this point. Judge McAfee has not set out a date at this point. Again, we are still doing motions, still different filings are due in the Georgia case, but this one was just filed today. Do you have knowledge of employment laws? Yes, I did work in employment law for a period of time. That would be another area of what we would call kind of a bread and butter area. No one's going to get rich off of employment law, but it's so important. It's such an important service people are doing. But yes, employment law is kind of a complicated area. You know, there is a really amazing creator on this app, and I am so sorry I have forgotten her name. I think it's maybe Attorney Paige, I think is her name, and she is an employment attorney out of, I believe, St. Louis. Oh my gosh, she has got some amazing content. So she does great work when it comes to employment questions and employment issues. Is that right, Kate? Okay, yes. Okay, great. Yeah, she's great. I think she does just a really great job. I find her posts to be very helpful in sorting through some of those issues because they're going to change depending on which jurisdiction you're in. Every state has different sets of laws, and some states are extremely different than other states, especially regarding contracts and at-will employment, so those kinds of things. Yes, Paige. Okay, excellent. I'm glad I had the name right. Will anything be broadcast that we can watch? So I believe they're going to have oral arguments, just the audio available out of the DC circuit. I believe they had the last one available, so that's what I'm hoping. I will be tuning in if they do make it available. I will be going live during those arguments, hopefully, as long as everything comes together. Need to go. Well, take care. Have a great day, Charles. Always good to see you. Paige Sparks. Is that, I'm not sure what her last name is, but she gives so much effort. I'm wondering if you're talking about Paige, because she certainly does. She really does. She does a great job. Let's see. What was another question? Do I have a specialized knowledge? I guess I would say the area I've focused a lot on has been the Constitution. That's been where I've done most of my teaching, and then spending a lot of time within criminal law, criminal procedure, and evidence. Torts and litigation, of course, is always good, but my favorite area, I guess, if I had to choose, would be constitutional law. That's the area that I've spent the most time studying over the years. Can you explain how you're annotating? Sure, of course. So I'm going through, again, everyone, just to kind of bring us all together. This is a 70-page motion, so I'm not going to be reading it. And because it's very similar to all of the previous motions that have been filed by Mr. Trump. So he has filed a motion to dismiss the indictment in Georgia based off of presidential immunity and the supremacy clause. Now, he's filed to dismiss in Georgia for multiple reasons. They've done motions for demurs, they've done all kinds of things, and they've even had hearings about it already, and even what the meaning of the RICO statute is. It's all online. If you're interested, you can watch those hearings. So he's filed another one today, and so how I like to annotate, first, each of the cases involving Mr. Trump, because there's so many, has a different color. So Georgia is green, and then Mr. Trump as a defendant, he's orange. And so I usually will highlight that. Next, whenever I find really important case law, so precedent, I always highlight in pink. When I'm separating out the subheadings, I'll usually just use a yellow or a very light one. Any big rule of law, which I'll come back through again. I usually pass through these a few times, but like for example, the Constitution is here. So I will put the constitutions or statute or rules of evidence, or even if there is a law review article, that would be in blue. So pink is for case law, always, and I always have done that since my first day in law school. That way, when I look at a piece of paper like this, rather than being like, oh my gosh, there's so much, I'll automatically know they're going to have 4 or 5 different cases they're talking about on this one page. So I'm able to pull it out very easily that way. Yep. And that we really have a lot of, we've got a lot of, if you were just to look at this, if you just look here, this is overwhelming. Even with this indent, in my opinion, I think it's overwhelming when you're trying to figure out what all of this means, or even something like this with a huge block. And so I find that if you annotate by pulling out the different parts of it, and all cases have the same exact parts, they just say it differently, it makes it a lot easier to get through the case and also find what you're looking for. This technique has been a lifesaver for me when I've been standing up in front of a judge, either in an appellate judge or in front of a state Supreme Court, and they ask you a question about the case. Well, what case were they relying on? So I can go immediately to the section that I know it's in and then look for whichever pink ones have been highlighted and pull out my case. It has saved my life when I've argued in front of judges. And so I just continue to do it. A lot of attorneys don't continue to do it after law school, and that's absolutely fine. But for me, I found I'm quicker on my feet if I have everything color-coded and ready to go so I can answer the judge's questions. So that's why I just continue to annotate. No post-it for today. Yes, I'm flipping through just a little too quickly today, everyone. And then also making sure to try to catch everyone's questions. So I apologize. I know there'll be a lot of questions on what I'm highlighting here, but I am just moving too quick on this. So usually I would put one up, but I'm flipping over. This is just my first pass through, so I'm just going through and hitting the cases. Right now, I'll go back through again and hit all of the law. If I note the Constitution, sometimes I'll highlight that as I go through, but this is just my first pass through, and then after that, I'll start annotating other pieces of the case or other pieces of the motion as well. How many years did you teach law? That's a good question. I think, let me see, the last year, okay, it was 13 years, 12 years. Is that a lot? It seems like a lot now that I count the years up. That seems like a lot. But yes, I think if I count the years I was given a paycheck when I was teaching, then I would say I'm at 12, 13 years. So that's a chunk of time. Had a lot of fun doing it. I think so. I think judges do appreciate it. How many appeals and motions can Trump utilize? As much seems to be repetitive. He can keep doing it for each one. So for each motion, you can appeal or you can respond, you can reply. So for each different thing that's getting done, there is an opposing motion that you can file, and he is. Do you have to? No. But is he? Yes. So it goes on and on. It seems like it's endless because it feels endless. And we have a lot. We have a lot of the same things. We have the same kinds of cases. This case itself, the Blessing Game case, for example, which was decided out of the D.C. Circuit. So this is the prevalent, the most important, up-to-date case when it comes to presidential immunity. And this was the case where the D.C. Circuit, so the one hearing the case tomorrow, came out and said, hey, were you speaking on January 6th in your presidential role or as a candidate? We think you were doing it as a candidate, and so presidential immunity is not going to apply to you in this situation anyway. So something like that. This case is they are suing Mr. Trump for damage that was done to them as officers and representatives that day. So again, this is the holding right now in the district court in DC, or in the appellate court in DC. Higher ed from 10 years. It's been a long 10 years. Oh, absolutely. Oh my goodness. Yes. Is the New York case over? So if you're talking about the New York civil case, that has closing arguments coming up on this Thursday. So closing arguments are set for Thursday. All of the evidence has been presented. All of that element has been done. But closing statements are Thursday. Closing statements aren't law. They're persuasive arguments. And after that, Judge Engron has said he should have an opinion for us within a couple of weeks. Before the end of the month, he said he should have his decision. So, of course, we'll have closing statements then on Thursday, and then whenever he delivers his decision in the next couple of weeks. So that's the civil case. Now, the criminal case is still ongoing. We still are fighting motions to dismiss. We're fighting motions to compel discovery. There's lots of things still going on in the New York criminal case, which is technically set for trial that third week, I think, in March. So we're still set for trial on the New York criminal case. So that one's still ongoing. And that is the hush money fraud case. Thank you. Oh, you're welcome. Of course. Of course. Do you think he's trying to stretch this out past the election? Probably. Yeah, I think so. I think there seems to be this idea of this kind of like shield in place. So long as he is campaigning, there's this extra protection. But I think what he's finding out throughout a lot of these cases, for example, like in the Blessing Game case, is that protection's not really there. That protection he thought he would have by declaring running for presidency is not really there. He's definitely using it in the court of public opinion, but in the actual, four walls of an actual courtroom, it doesn't play out the same. So I think that's becoming a bit frustrated for him, in my opinion, in my humble opinion. My thinking too, yeah. Is the RICO case going to go past the election? Now, I don't know. I do know that D.A. Willis has requested that it be set for August. Now, the other thing going on here in this again is the Georgia case. I'm just annotating this motion filed for immunity here. The other thing that's very interesting is Judge McAfee has said he would like to see this case split up. He would like to see it in not just one massive trial with all 15 defendants that are left. He'd prefer to see it broken up into 2 or even 3. That's his preference as the judge. That's not been decided on, but he has kind of made those thoughts known in many of the hearings that he's had. So I'm not sure exactly how that would set up. I'm wondering how. The reason I bring it up is because I think it's helping D.A. Willis in going forward with her plea negotiations, of which I have no doubt she's working very hard on. So depending on who gets pled out may be enough to get the number down to a reasonable number that the judge is more comfortable with in order having it as one trial. And so if they have lesser number of defendants going forward because the others have pled out, it's much more likely for one trial to go kind of in that August range or even September, and that's still before the election in November. That's my thought. that would take a long time. Yeah, I mean, the trial's going to take a really long time. He had been indicating he wasn't going to run and then got wind. Yes, there were some questions. And actually, his announcement to run, the timing of it is very unusual as far as historically goes. The timing of when most candidates announce versus when he did. But at this point, every time I say something's unusual, it just doesn't even mean anything anymore. Like, well, that's weird. And then like, what? That's just how things are. That's just how it is these days. He announced very early. Yes, he did. And also, the other thing too, as a side note, the RICO case, if you're talking about that taking a really long time, yes, absolutely, it will take a long time. I wouldn't doubt, even if the RICO case got started in August, it wouldn't be finished until after the turn of the year, but it would at least be started before the election. I think that that's fair to say. If it was going, but again, we'll have to see if how many will plead out before the time comes around, and if she can get that number down to something that's a bit more palatable, I think, for Judge McAfee, then you'll see it go forward quicker. Do you see any flaws in the cases against Trump, in your opinion? So, I'm glad you asked, actually. Legally, when I look at these cases, all four, all right, if I'm looking at the two, let's just start with the federal cases. The DC case along with the Florida case. I would say the absolute most solid case is the Florida case by far. It is so cut and dry. It's what I would call a strict liability situation where we have a law. Did you break it by having the documents? Yes, we're done. It's so cut and dry. The biggest problem is all of this is, I guess, the fact that it's, and I think I was saying this a little bit earlier, that Mr. Trump and his cases, it's like a dumpster fire. So the biggest problem with these cases is that they are on fire. And so the public and everything that's involved in it is getting constantly burned by it. So the legal theory, the legal premise for all of these seem pretty, clear cut as far as just the legal premise goes. If it was somebody else, if it was anybody else with these same charges and these facts, I would say, all right, looks good, let's go to trial, get her done. But because it is Mr. Trump, everything's on fire. And it just makes it almost impossible to move forward with any kind of speed or due process, with any kind of resemblance of sanity, because everything's so hot. That's what I see as the biggest problem with these cases, is just the star quality to it. And usually we don't have, if you think about some really hot contested cases that we've had over time where people choose one side or the other, maybe the Johnny Depp case isn't a good example because I'm not sure. Well, maybe it is. People were choosing sides, right? And so people get upset about that and they post things about it and there's all kinds of stuff about it. But, nobody's going completely armed for bear to someone's house involved in the Johnny Depp trial. You know what I'm saying? We're not dealing with the same level of interest in any other kind of case. And so, of course, that's going to have an effect on everyday people and on the people that are jurors seeing all of this going on. We're just dealing with a very different set of circumstances because of that. Why aren't they moving forward with the other cases? They are, Sheila. They are moving forward. It's just slow and steady. Again, you can't rush it because everything has to be done exactly right, because everything will be appealed every step of the way. And the appeals go smoother if everything's done completely correctly at the lower level. And then by the time it gets to the appellate court, like for example, in DC tomorrow, by the time it gets there, everything's been done that could possibly have been done to preserve and to check everything in that argument. So all they're going to need to do is listen to the arguments and then come back with a decision, which should come back pretty quick. So there's not going to be a lot of contemplating because of how careful Judge Chutkin was and because of how careful everybody was at the lower court level. So it takes a long time, but it takes a long time in the front end to help with the appeals in the back end. You think more states will remove him from the ballot? Absolutely. Absolutely. I think we will start to see that much quick. I would be surprised if we got through this week without seeing more states filing. I think we're going to start seeing cases every week of states filing. I do. I really do. Can judges above canon hold her accountable and say she should move this along? No, they don't. They don't really have that kind of authority. So she does have, if she gets appealed, right, that means she would get reversed if they felt that her actions were out of line. But first she would need to make the decision, then it would need to get appealed, and then they would need to reverse it. So there's multiple steps. It's not like they can just go and knock on her door and be like, you're out of line and we're taking you off the case. It doesn't really work that way when you're assigned particular cases, and they do that in order to protect judges and give them the protection that they need in order to work a case. They don't want to be afraid of losing their job because they're making really difficult decisions on a really tough case. So that makes sense that those protections are in place, but then it also just takes a really long time. Uncharted territory. Yeah, lots of unknowns, exactly. So I have no doubt that she is probably getting advice and getting words of encouragement from, her people that she relies on and trusts. And I think that that's great. But ultimately, the only way to truly check a judge is if she recuses herself, which I doubt would happen, or if she gets reversed on an issue on appeal, which, could very well happen. And in Florida, in the Florida case, Jack has said he's not opposed to doing that. If we need to do it, we need to do it. But that really stalls things out quite a bit as well. So we want to keep things going. You don't want to have all these kinds of interlocutory appeals, which is one of the reasons why it's such an interesting amicus brief that's in front of the DC case tomorrow. They're saying, these kinds of appeals are not appropriate because it slows everything down and it keeps us from being able to go forward with our justice system, which is a valid point. So you want to be careful. You have to have special circumstances where an interlocutory appeal or appealing in the middle of a case before it's decided, you have to have a special situation in order for that to be appropriate. And we'll see, because it's very possible the DC court may find that this interlocutory appeal in the DC case is inappropriate. And going through and reading the case law that's set out in that amicus brief, it's very possible that the DC circuit can say, you know what, you're right. This isn't ready yet. This isn't right. This isn't the correct grounds for an interlocutory appeal. Go back, try the case, and then we'll take it after it's done. That could very well happen. Will it? I don't know, but it could. It could happen. They've got a good argument for it. So the DC Circuit may just toss it back down to Judge Chutkin to try it and to get it done. That would be the scenario when that March trial date actually stays in place or something close to it. That's the only scenario in which I see that trial date really coming back, is if they kick it back down because they say, look, we just don't have jurisdiction. But if any other decision comes out other than, we don't have jurisdiction, it's not a good interlocutory appeal, then I think that March trial date will get moved, in my opinion. That's just my thought. Did I say circus? Yeah, I'm trying so hard to not say 8th circuit, because I get the 8th and the DC circuit mixed up so much. So is Jack gonna go for the Congress members that supported? That's a really great question. A lot of people have been asking it, and I don't know. I would say if anyone would, it would be, Mr. Smith. He's got a pretty good way of and he's done it before too. He has no problem. It doesn't matter who's doing the wrongdoing. He doesn't, he'll go after you. He'll go and get you. Again, I remind everybody of, who was it again? What was his name? Was it John Edwards? That he went after when all of that information came out. So he's not playing around. He'll go get you if he thinks that there's grounds for it. Wow, somebody's formatting is not correct. Oh my gosh, you can tell when a student has cut and pasted something not very well. And so that's what I have right here, is a really bad cut and paste job. Yikes. It's gone after, yes. It certainly is a circus. Well, it feels like it. Yeah, prime ministers. Yep. For sure. Has there been movement on the discovery in Florida of classification documents? There's not been any movement on the discovery issue at this point, but the joint discovery report is due tomorrow in Florida. So we should have an update on what the status of discovery is tomorrow. That's when it's due, according to the last order that Judge Cannon put out regarding that. They should go after any member of Congress who committed treason. Well, right. We get down into this issue, though, of picking your battles, right? You've got to pick the most important pieces. And I'm sure when Jack first filed in order to go forward on the grand juries in the D.C. case and how careful he was with that, and the Florida case, he felt he had been as careful as possible, which is why we have a superseding indictment in Florida, because he was so careful when he filed that he waited until he had more in order to include that third person and those extra documents. So because he's so careful, you would think that, there's a reason why he's not filed anything further. There's a strategy to it. Yeah, there's a rationale. And I know in the DC case, he's really trying to keep that focus on Mr. Trump. That's why we have unindicted, co-conspirators involved and various things of those levels, because he's focusing on one defendant, which is different than this case. This is the Georgia case where, we had 19 in it. It's a circus. It absolutely is a circus. But that's kind of the nature of a RICO charge. So sometimes those things just can't be helped. But in Florida, we have 3 defendants, and he's already struggling with that, saying, with the most recent motion, saying, hey, is it just Trump that's using the advice of counsel defense, or is it everybody? Is it all 3 defendants? And if it's all 3, then you all 3 need to plead it, not just Mr. Trump. So he's already trying to corral them into making, decisions for everybody or one person in order to keep it all straight. So it's a bit of a mess. Wasn't there some talk about ChatGPT? What was that issue? I missed that. So I think some of the questions have been, whether or not ChatGPT has been being used in some of these motions, because some of the language seems a little bit different. But of course, I don't have any proof of that by any means. We're just kind of talking about it. And that's been in the media lately. Because we have had some attorneys who've gotten into a little bit of trouble. Michael Cohen, that's right, Law of the Wild, exactly. It's so interesting because, and I won't give out too much information, but that whole situation we had known about in my particular neck of the woods already. So we were all just kind of sitting by and waiting for the news to break so we could start talking about it. Because, our inside sources, we had already been talking about, like, whoa, why'd they file that? Oh my gosh. So it was very controversial, which I'm sure many attorneys in the field were already hearing some things about it, some rustlings about it before it hit the media also. Okay, I see I caught the end of the discussion. Oh, yep, exactly. So, but yeah, the ChatGPT thing, that's kind of a yikes. Now, the last motion I went through that Mr. Trump had filed, I went through and I was just circling phrases that were, not necessary. Wait a minute, are we citing an 1897 case out of Iowa? What? What are we doing here? Hold on a minute. What just happened? This is being filed in a state court in Georgia. What is this? What? Hold on. Okay, for the same reason expressed by its progeny, the state has no authority to involve itself through criminalization, exercise of... What are you talking? State criminal laws are not applicable to a pension examiner appointed under the laws of the United States for act done in connection with his duties as an examiner. Out of an 1897 case? Are you freaking kidding me? What is this bologna sandwich? And we've got another case out of 1899. Dude, update your sources. You can't, your sources are not, no. Oh my goodness, everybody. So this is why I cannot read some of these. I can't read some of these motions anymore because they just are so frustrating. Like, you can't just come in here and say state courts can't charge criminal offenses. Well, I guess you can because you did. But yeah, you're not going to win on that. And it really is, it's a waste. Or not, I guess. I don't know. It's frustrating, I guess. Maybe if the point is to be frustrating, you're succeeding. Back in the Neolithic, oh my goodness. There has to be at least one case in the last 100 years. You would think so, Law of the Wild. You would think there would be something. And, closer to Georgia, too, I mean, come on. I just can't. Oh, my goodness gracious. All right, so here's my next pass through. Again, everyone, I'm just kind of annotating this motion as we're discussing it. This is the motion to dismiss the indictment based off of presidential and supremacy clause immunity and supporting memorandum of law. This was filed by Mr. Trump in the Georgia case just today. So I'm just going through and annotating it here as we kind of talk about these issues that are going on. Oh my gosh, it's a delayed tactic. Well, I mean, everything is a delayed tactic. And when you have enough money and enough power, you can pretty much delay a lot of things as long as you want. But eventually, you will run the clock out. And, wait a minute, that's a sports term. What I'm trying to say is eventually the law will catch up with you. There is an end. Eventually it does happen. So you can only go as far as you can go. And then after that, the law will still be there standing there looking at you like, are you done? Are you finished? All right, let's keep moving forward. Oh my gosh. The Constitution. No, I wouldn't say the Constitution's, well, I don't know. The Constitution is, not frustrating, but it just leaves a lot of room for interpretation. So I guess depending on your interpretation, it can be frustrating. The first time, run the clock out. So you learned how to cite sources. True, Mads, true. Small little learning moments. We love that. Supporters only have so much money to... Oh, I know. It's a lot. It's very broad. And, I've said this before, too, that the Constitution is really just the foundation. It's just the skeleton. Everything else gets added to it as the years go on and we figure out what works and what doesn't work. And a lot of things don't work, like, the Electoral College and voting in some ways. So, we continue to add to it and clean things up as time goes on. So... but it was a good foundation. I think it's a very good foundation to at least start from. If people would read it, that would be great. That would really be great. I'm a big fan of actually reading the Constitution. I'm pro reading it. So, and actually I have right here, hopefully it won't be too shiny. Won't be too. But I have here one of the easiest things you can possibly get is, we call this a bar chart. Now, I'm not saying you need to go out and purchase anything. I'm saying that there are a lot of resources out there, and this is one of them. And what they have done for this particular one that I have is they've put the entire Constitution, everybody, into this laminated fold out. So the entire Constitution, all 7 articles, the preamble, all 27 amendments, every word in the Constitution is written onto this. So, if you think about it, I mean, it's fascinating to me that our entire country, everything is based off of everything that can be folded away into this one little thing. But it's a good resource because you can look and you can say, well, where is that at? Where is the, let's look to the 14th Amendment. It was passed in 1868. And how many sections? We have 5 sections. And mostly it's due process and equal protection in the first section. But we have voting rights that have been included. And then we also have this whole thing about, insurrections. So I think it's really helpful to have something like this so you can read it, because I think if you see how manageable it is, the Constitution's not as overwhelming as a lot of people feel. It's a menu. It is. Oh my gosh, that's a genius way of putting it. It is. It's and not even like a complicated one. It's not even like a Denny's menu. It's like just a regular mom and pop menu. Exactly. Like, I'll order Article 2, thanks. Oh my goodness. But yeah, and the more time you spend with it, the more you get a feel for how things are working, and it's less overwhelming. Citation from 1909 case involving a bicycle, a porpoise, and an ice cream cone. It's probably coming up, right? It needs to be edited with, well, I mean, come on, Stephen. I'm just lucky that oh, the language, that's not the first language I would edit out of the Constitution if I had a chance to go after it with my own quill. The pronouns are the least of my concerns with the language that's already in the Constitution. There's some pretty shady language bits in there, but I understand where you're coming from on that for sure. Thank you for doing these lives. Helps with the actual cases and explanations. Oh, good. I'll order an Article 2, Section 2, the side of Section 3. Okay. All right. It'll be 20 minutes. Don't forget to tip your waitress. Oh my goodness gracious. Oh, funny. But yes, I mean, it's really not that bad. What would you change about it? Well, there's some language in here that is pretty distressing. There's a few pieces in here that I think should be completely removed if possible, but that's just me, you know. I don't particularly enjoy the what's for dessert? Yeah, so for me, I guess the first thing that pops into my head, of course, is the language in the 13th Amendment that creates the loophole there for anyone who is sentenced to a crime. The loophole in the 13th Amendment, the slave refugee piece of it, also I would get rid of immediately. I think that kind of language troubles me the most because it was originally written into the word. So it's well beyond an idea of identity. It goes into property issues, and I think that's so horrific that it's deeply upsetting. Rights added much later on. Yes, exactly. Fourth Amendment seems to be take it or leave it type of dish. It does. It depends on who's ordering it. But it does seem to be the most frequently ordered one. For sure. Oh my goodness. If it was a menu, I would say that's the most popular item would be the Fourth Amendment for sure. Probably followed by the First. Oh my gosh, yes, that one gets served up every day. Without a doubt. Oh my gosh. Yeah, I think Barrister was talking about that the other night, that the Fourth Amendment's one of those super highly litigated, and he's absolutely right. He is absolutely right. We litigate that Fourth Amendment so much every day, all day, every day. It gets litigated all the time. Not the second. You know, the second, okay, here's the deal with the second, everybody. I get it. The Second Amendment's very important, blah, blah, blah. I get it. But it wasn't incorporated until like 2012. Help me out, Law of the Wild. Was it 2012? I get 2012 and 2008 mixed up. So we had two cases, the Heller case and the McDonald case, and it wasn't even incorporated. So it's really only been incorporated for about 10 years. So because of that, it just doesn't, thank you, Law of the Wild, it was Heller. So because it hasn't been incorporated, it just doesn't have the history. And so if you look at the amount of history that the Fourth Amendment has compared to the history of the Second Amendment, there's just no competition. I'm sorry, Second Amendment, I don't want to hurt your feelings, but that's just how it is. It's just a numbers game. It's just strictly numbers, everybody. I'm not trying to pick on everybody. Oh my goodness gracious. Fourth Amendment challenges are brought every day in every courthouse in America. Exactly. It is absolutely one of those huge litigated pieces, and rightfully so, because, you know, you can be searched and seized. It just can't be unreasonable. So we have to have someone deciding that a reasonable level, and so that question is left to the courts. What do you mean by incorporated? Sure. So, all right. Okay. So All right, so back in the beginning, originally, everybody, the first 10 amendments, the Bill of Rights, were only to be applied to the federal government and not to the states. I know, it's madness, but that's just how it was. That was decided by the U.S. Supreme Court. After the U.S. Supreme Court made that decision, years and years later, they said, oh, I'm not so sure. I think after the Civil War with the 14th Amendment, I think we can start actually applying some of those Bill of Rights to the states through the Due Process Clause of the 14th Amendment. So it wasn't until after the Civil War, so after 1864. Before that, the Bill of Rights didn't apply to the states. Did you have freedom of speech? Yes, if it was the federal government. What about freedom of speech against your own governor? No, because you didn't have a First Amendment right unless your Constitution had it. That's how it was until the Civil War. It's just how it was. After the 14th Amendment got passed, after decisions were made, they eventually decided to incorporate it. That means slowly the U.S. Supreme Court would review a case regarding a state use of a Bill of Rights. And they would come in and say, okay, so now this part of the First Amendment applies to all states. This part of the not the third, that one doesn't apply, or the Fifth Amendment applies to all states. Slowly, they built it up until almost all of the Bill of Rights were now applied to the states. So there are still a few things that do not apply to the states because the Supreme Court's never heard a case about them. But other than that, all of the rest of the Bill of Rights have been applied. To give you an example, it was just a few years ago that the unreasonable fines and bails under the Eighth Amendment was actually incorporated to all of the states. I think it was 2018, actually. It was a decision out of, I believe, Nebraska by Ginsburg, where finally that piece of the Eighth Amendment became part and applied to all of the states. So it's called the incorporation doctrine, and it's complicated and it's messy, but it has to do with how the Supreme Court set out judicial review. The Third Amendment, right. So the Third Amendment to be incorporated, I know. Now, listen though, the Second Circuit, as I've said this before, I'm going to keep pushing for this. The Second Circuit has said that they believe the Third Amendment does apply. So technically, the Third Amendment does apply in the Second Circuit. Just none of the other circuits have held it yet, and it hasn't gone to the Supreme Court. But the Second Circuit, it had to do with reservists, I believe. No, what was it? The, not the reservists, what's it called? National Guard. Yes. Oh, you're welcome. Yeah, so it's a fascinating situation. But right now, so here's how it goes. The Third Amendment is not incorporated. The Seventh Amendment is not incorporated. The Eighth Amendment, the last piece, just got incorporated. The Ninth and the 10th Amendment are not incorporated because of the language, so they really can't technically be incorporated. So there still are those pieces. And then there's another piece to being indicted by a jury trial under the Fifth Amendment. That piece of the Fifth Amendment's not been incorporated yet either. And that's why you don't always get indicted by a jury. Sometimes you get indicted by a trial information. So let me show you what I mean here. So right here, this is the Fifth Amendment. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment of or indictment of a grand jury. That part does not apply to the states unless it's in your state's constitution. That only applies to the federal government because that part of the Fifth Amendment's not been applied by the Supreme Court. So technically, your grand jury is only at the federal level. At the state level, they can file paperwork or another way of filing an indictment, depending on what their constitution says. It's a states' rights situation. And that's because this part has not been incorporated yet to the states. No jury required in civil cases. Yes, and that, I believe, is the Seventh Amendment here. So in suits at common law where the value in controversy exceeds $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. So the civil trial with juries is that Seventh Amendment. So the Third Amendment, that piece of the Fifth Amendment, the Seventh Amendment, those pieces have not yet been applied to the states. Yep. I know, interesting, right? Fun facts. Fun, interesting. I was today years old when I realized every state has its own constitution. Well, fair enough. I mean, if you've never had to deal with it before, why would you know it? Really? I mean, we all focused on what we focused on when we were in school. I certainly know that there is something called algebra, but hello. That's just how it is. This happened to be the subject that I focused on because I was interested in it in school. But there's lots of other things involving different types of triangles that was taught. And I'm like, whatever. A triangle is a triangle. I get it. 3 sides. Move on. I don't know. Oh, my goodness. The federal government deals with civil trials. Great question, Brian. So if you're suing in a federal court, okay, then your 7th Amendment rights are going to be applicable in how that works. And there's kind of funky language that works with that. But what I'm talking about is each state then has its own rules regarding civil trials. So rather than having this kind of, freedom of speech across all the states, now we have a state by state when it comes to jury trials and civil cases. It will depend. So your rules for a civil case in Texas are going to be different than your rules for a civil case in New York. Unlike your rule for First Amendment freedom of religion is the same right that you have for freedom of religion in Texas as you do in New York. So those rights are just different in civil cases because of how the laws are written. Yep. There's something called algebra. Well, apparently, I've heard of that. I heard a rumor. I've heard a rumor. Is there a law for dummies I can read because I can't retain all of this? Well, it'll come back to you when you need it. All right, just know it'll come back to you. If you don't need it, why would you know it? And you can always look it up. The point is that now that there are good questions that you can ask. And so that's really what the lesson is. You just think you know everything, but you don't. And I feel that way all the time, every day, all day, every day. I'm like, oh, I knew that. Like, no, I didn't know that. How many credit hours are we earning here? I haven't applied for CLEs. I probably should. I should. Is there a way to become a lawyer with no law school? So technically, it depends on what you mean by lawyer. That's a terrible lawyer answer. If you want to be a licensed attorney, you have to go to law school because you have to have a law degree in order to take the bar. There may be some exceptions, but I do not know of what those exceptions would be. But if you want to work in the law area, there are a ton of other ways to do that do not involve law school. There's a ton. So you certainly don't have to go to law school in order to be in the legal business. But if you want to practice, you need to be licensed. In order to be licensed, you've got to take a bar examination or whatever kind of exam is required by whatever jurisdiction you're going into. TikTok CLE. Oh my gosh. Pass the bar without law school. Yes. Yeah, I suppose it's possible. She's doing the baby bar. Oh my gosh, the California bar, everybody. That's a monster. Oh, it's a beast. California and New York and Illinois, oh my gosh, they're just absolute beasts. You don't need a degree, but many people do. If you can pass your bar without having to get a law degree, if there's a jurisdiction that allows for that, I've got no problem with that. I have no problem whatsoever with that. I just am not familiar with that myself. I just don't know of those. Just announced non-bar. Really? In California you can. Okay. She passed the baby bar but failed the other one. So, the other thing too is they're about to change the bar. They're about to change it. It's going to be like they're referring to it as the new bar. So the formatting is going to be different. And I'm not sure. I'm not sure how it's going to turn out. I'm not sure if it's a good idea or not, but it's a huge issue that's been going around. The bar exam has been controversial since its inception. We will see how it goes. How likely are you to get hired by a firm with no degree? It's a great question, David. I do not know. It would be very hard, I think, to get hired just by testing out of law school, which I think there's nothing wrong with testing out like that and taking your bar exam and passing. There's nothing wrong with that. but it would be very difficult to prove that you had the chutzpah to go forward on it. People make money in California to help people pass it. That sounds, I mean, yeah, and if you can, go for it. But, you know, California does things a little different. They're a little different in California. Like Louisiana's got their own Napoleonic code. California's a little different. They have their own way of doing things, and that makes them special, and that's okay. We're all different. You can be a student and we're, yes, absolutely. Recruiters seem to look for law school grads. They do. And again, though, it depends on what kind of law you want to do, what area you want to go into. But if you're looking at some kind of, you know, big law career, yeah, they're going to want you to have the firm experience typically. At least that's how it is right now. You know, in 5 years, I don't know what it's going to be like. You know, the legal field is changing so quick right now that, you know, there could be different standards. Army paralegal, he has the option to take the bar after so many years. Oh, that's fantastic. Oh, I love that. That's great. Well, good for him. Didn't Abe Lincoln read for the... I think so. There were several people that did. And that's fine. I mean, the law is about, you know, rules and procedures. And if you can understand those and you can do analytical reasoning, you know, why can't you pass the bar? Why do you have to go to law school if you can hit those points? And many people go to law school and still can't and take the bar 2 or 3 or 4 times. And with that, I don't think there's any problem either, because every time you take it, you learn more and you get better at how to take the bar, and that knowledge stays with you forever. So I'm not sure there's any right or wrong way to go about it, in my humble opinion. You can substitute many years of experience. Well, and I think that's great. And it's that philosophy that I think is really what's the driving force behind the new formatting for the bar that they're going to be having in place. I think in 2025 will be the new bar. I think that's a soft think. I'm not sure. But that's the whole basis, is the actual experience in the field doing the actual kind of work. And so rather than sitting and doing an academic question on blah, 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 actually going through and writing motions, writing pleadings, writing a brief, writing these things out and getting graded on that kind of, you know, in the field work, as opposed to, you know, philosophical academic questions. That's one of the driving forces, because there's really no substitute for in-field work. There really isn't. There's not. Have you seen Alina Haba? I'm not sure. Oh, yeah, I saw it. Okay, so I saw a clip of her talking about how Jack was in contempt of court, and I just, after that, I was like, I gotta go. I couldn't watch any more of it. I don't know. You know, I'm not supposed to speak ill of other attorneys or our profession, but yeah. So there's that. Lawyers have to take an oath to defend the Constitution. Yes. Well, I mean, the question defend. I don't know if defend was in the oath. If it was defend, I know to follow, support, uphold, enforce, all of those words. I think defend was in there, but yes. It's painful to watch her. It is. And we have to. And that's the only way we can go forward and practice law, is by taking that oath. And I remember taking the oath and how important that was, and never looked back. Never even thought about looking back. But, you know, everybody's different. Go read my pencil. Yes, go for it. I mean, every constitution's a little bit different. Did you hear what she said about Kavanaugh? I didn't. I heard that there was some talk, but I didn't actually hear what she said. And, you know, that's not cool. Don't get me wrong, we all say what we want to say about different justices, but hopefully, I thought it had something to do with how he's like being ungrateful, maybe. Was it something along those lines? That he was ungrateful because Trump put him in that position? Because those kinds of comments seem, you know, out of hand. Those seem to be inappropriate, unprofessional. Right, Kavanaugh owes Trump. Right, right. Okay, exactly. Thank you, Suze. Yeah. Because to even imply that is unethical. To imply that a Supreme Court justice owes anybody some kind of allegiance goes against our profession. I mean, we all talk about it. We all know what happens, but you don't just go out on national television and say, hey, U.S. Supreme Court impartial justice, you need to say thanks to the person that put you in your spot. Like, what? Right, against the oath. I agree. I agree. She's walking a line. That particular attorney, she's walked over that line multiple times. And the thing is, it seems to me, in my humble opinion, she's going 150 miles an hour and she's just busting through whatever she wants to bust through. But pretty soon she's going to stop moving. And when she stops moving, that's when it's all going to come crushing down. And that's what I see happening to her, is once all of this settles, all of the damage that's been done is going to come back to her. Trump's whole plan to have a court. Perhaps. But I think that underestimates the power of the ego involved in being a Supreme Court justice, because you may have done whatever you needed to do to get on the court, but now that you're on the court, you are your own person. And many times that's shown over and over and over again. I think Chief Justice Warren was a great example of that. He's like, look, I did what I did, and he did a great job. He's an amazing person with an amazing story. But once he got on the court, he's like, look, I got to go with what I think is right, as opposed to what you want me to think is right. And that's what I'm going to do. And that's what he did. So, I think things change once you actually sit on the bench. No quid quo. Yeah, quid pro quo. She was just let go. I don't think so. I haven't heard that at this point. He's got a lot invested in her, so I'm not sure it would be a wise business move to let her go at this point. Do you mean Earl Warren? Chief Justice Earl Warren? Well, he was governor of California, so you got to be political to do that, right? But when he sat on the bench, things changed as far as what he was advocating for, so he had to be more careful about that. Yeah, she is pretty, well, that's another thing too that we talk about, like, well, we should talk equally then about the males, right? Of course. That's something like, well, she has a certain appearance about her, true. But then you also say, well, the other attorneys have a certain appearance about them as well. But the other thing too, though, is that she really pulls that bright light down onto her face. That's where she wants to be. So I don't know. It's hard to get into appearance issues because, it's a really triggering area, I think, when it comes to appearance. But I have to say, she certainly does have a particular look about her that seems to appear quite a bit in Mr. Trump's circles. And I don't say that with any malice. I just say that as an acknowledgement. Giuliani's downright gorgeous. True story. Oh my gosh. I think that's Trump's view. Well, that's the question though, right? Is there a certain kind of person that people like, and is it because of their appearance or not? I don't know, but I guess the answer is yes. I do know. People go for appearance. That's one of the things that they always go. Play to your audience. Yes, I think so. I think that's true. What Jack's team looks like. We don't, David. We have no clue what they look like. We barely know what any of our judges look like, and that's already kind of been, just think about Judge Engron smiling that one day, how that turned into like a huge trending issue, like, a man can't smile or a judge can't smile, all of a sudden you're done, because it could mean anything in the entire world. So like there's no way to win. There's nothing you can do or say where you're going to win, no matter who you are in that situation. Don't ask him about the civil. Yeah. Civil War is amazingly triggering. A lot of people don't realize how triggering it is unless you're in a part of the country that finds it triggering, and then you know all too well. Oh, the Mentos commercial. No! Oh my goodness. Oh, will we ever recover? I don't know. I don't know if any of us will recover from that. I just don't even know at this point. All right, well, that was my second pass through, everyone. Oh my gosh. So that's about the extent of how far I'm going to go with this motion. Again, as I've noticed, it's similar to all of his other motions that he's filed regarding absolute immunity, only this time we're in a state court and he's filing it again. So here we go. Oh my goodness. People have, well, yeah, I know. Yeah, Judge Chutkan got swatted over. I don't know about that. I didn't see any of that. I didn't see anything wrong with anything she did. But, oh, do you mean swatted? Oh, I'm sorry, everybody. I just showed my lameness. She got swatted. I got you now. And let me add, oh, that's awful. That's too bad. And I hate that that's happening to our judges. Hopefully everybody caught me with that one. Originally I was like, what? And then I was, all right, we're there. I entered into full babble town. Oh my goodness. I hope she's okay. I hope all of our judges are okay. And, I don't care which judge it is, if it's Judge Cannon, if it's Judge Chutkan, I don't care who it is. It's just, they're just doing their job. And maybe we don't like how they're doing their job, but they're just doing their job nevertheless. So I had to Google swatted. Yes, I forget. That's a new term that has come out. So sometimes I forget our new terms because I'm an old lady apparently. Oh my goodness. Well, anyway, with that, everyone, I will go ahead and sign off again for my second live today. Just as a friendly reminder, for those of you who joined me this morning, I did add on the SCOTUS briefs here that are due onto the schedule. I will be posting about what's coming up on the schedule pretty soon. I'll have a post up very soon going over that. But we do have oral arguments in the Court of Appeals tomorrow for the DC Circuit. And if those are available live, hopefully I will be able to go live as well. So you can kind of watch for me there. Do I have a Patreon account? I do not. Nope, I don't. I don't at this point. I might at some point, but so far I've been very thankful for all the gifts and subscriptions so I could buy as much toner as I've needed. So that's my toner fund, and I'm very thankful for it. I'm extremely thankful for it. So then we've got the civil closing statements in New York on Thursday, and we'll see what happens. So I will absolutely be back Tuesday and Thursday this week at 7, but I'll be kind of popping in and out with various different pieces. This was my second live today to go through this Georgia update. We did a Florida update earlier, and so I will be back again at some point with various updates as time goes on. But this week is going to be a little bit bonkers, so I'll just kind of be coming in and out as time allows. So what time is it tomorrow? I'm not sure exactly. I'm going to have to double check when it's set for. If I believe it's going to be 9 o'clock Central Time. So I'm not sure. That would put it at 10 Eastern, I believe. But again, I'll have to double check on that. But I will be back again soon, everyone. Thank you, as always, for hanging out with me. I appreciate it. It's always great to see everyone and have so many great questions. So I will catch up with all of you very soon and look forward to chatting with you next time. Have a great rest of your day, everyone. Take care, and I will be back again pretty soon. Goodbye.